Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss the case of Jones LNG LASALLE Properties Consultants versus Deputy Commissioner of Income Tax. This case has been reported in 447 ITR at page number 40. The matter has been decided by Delhi High Court and the date of the judgment came on July 21, 2022. Friends, the purpose of discussing this case is just to throw light that how slow our administrative system is in fiscal laws when the question comes regarding disposing of the applications, disposing of the grievances filed by the assessee. The department more or less just keep those applications into their drawers and they do not react, especially in those cases when there is going to be some benefit to the assessee, when there is going to be some relief to the assessee, or whether when it is a matter of lowering down the litigation. In the present case, the assessee has filed a number of section 154 applications. If those applications were disposed by the assessee, by the assessing officer on time, then whatever the demand which was there on the portal of the assessee will be vanished. But the assessing officer was not bothering to dispose of those applications under section 154 in spite of repeated request by the assessee. In the meantime, the assessee filed the application under section 197 for seeking the lower deduction certificate. When this application came to the department, the Deputy Commissioner of Income Tax simply cited rejected this application by saying that there is a lot of demand outstanding against the assessee on the income tax portal, so we cannot give you the lower TDS certificate. First of all, this is very illogical. Even if the demands are pending, then you go and collect the tax from the assessee. But if in the present situation the assessee is not earning much amount, his tax liability does not come out to that extent to which the TDS is deducted, then the lower TDS certificate under section 197 should not be dependent on how much demand of the assessee is outstanding on the portal. Those demands are with regard to the previous assessment years. First of all, this point is not logical as far as my knowledge is concerned on the part of the Deputy Commissioner of Income Tax. But apart from this, the height came when the Deputy Commissioner of Income Tax himself admitted into the rejection order that there are a number of applications under section 154 pending filed by the assessee, and if those applications will be disposed of, then the demand of the assessee will vanish. In spite of this, he rejected the application of the assessee under section 197 for the lower deduction. See the height of the unresponsive behavior and the bureaucratic behavior of the officers, that they know that there is practically no demand of the assessee and they have to dispose of the applications under section 154. They are not disposing of those applications, and in spite of that they are rejecting the new application of the assessee because the demand is pending. Even if the demand is pending for the earlier assessment, yes, you cannot withhold the certificate of the lower TDS certificate for this year, because this is to be seen in the present context. If the demand is pending, then it does not mean that whatever the assessee will receive in future, that should be deducted into the form of TDS. So, in this present case, the assessee moved to the High Court. The High Court said that the Deputy Commissioner of Income Tax or the department is making the contradictory statements. So, the High Court directed the department to dispose of the rectification applications of the assessee as per the law and then accordingly decide the matter. Friends, this seems to be a very simple matter as far as the big clients are concerned, big assessees are concerned. But if this is a matter of a ordinary assessee whose refund of 3, 4, 5 lakh is pending and they are behaving in this manner, then every assessee cannot afford to go to the writ court. Going to the writ court is not an easy job. But this is the fate of our tax administration system. So at the end of this video, once again I am repeating the name of the case. The name of the case is Johns LNG LASALLE Property Consultants versus Deputy Commissioner of Income Tax. Thank you, friends.